Welcome, everyone. Welcome to Resolution Institute's lunchtime session on mediating loss for a humane society. My talk today will focus on how aspects of law and psychology combine in the process of mediation to make sense of the loss that gave rise to the dispute, and how acknowledging the grief arising from that loss creates a more humane civil society. I use the word humane deliberately and will discuss its significance later in the talk. The argument I make is that the process of dispute resolution is itself a continuum with law at one end and psychology on the other, and that engaging this continuum becomes an act for social change. That is, I claim that resolving any dispute changes the actual society in which that dispute arose, hence the cliched term for the ever-changing nature of society itself. These claims might sound bold, but I will now explain how I came to make them. As a psychologist with over 40 years of experience and a barrister mediator with about 30 years, I realised that there are more significant commonalities between the two professions than there are apparent differences between them. The main similarity is that both psychology and law attempt, in their own unique way, to address the question of loss arising from shattered expectations. For instance, the loss could be one of self-esteem in psychology, for which the client seeks the assistance of a psychologist, or a loss resulting from a breach of contractual obligations, for which the assistance of a lawyer is sought. The answer that both professions have in common to the question, why do people go either to a psychologist or to a lawyer, is to redress the impact of grief they feel from some perceived or real loss. The research around this answer culminated in my PhD in law, majoring in dispute resolution, which I have called the Reconstructionist model of mediation, where I make the claim that the very reason for conducting any mediation is the quest by the parties to reconstruct meaning around their losses to make sense of their loss. This quest for reconstructing meaning around loss is what I claim to be the theory behind the practice of any mediation, such that I further claim that loss fuels the meaning we give to life. As I only have 45 minutes to give this talk, I'll present my findings and then take any questions if we have time. So, to begin, mediation has often been claimed by notables in the field, such as Lawrence Bull, as a practice in need of a theory. As a psychologist and barrister interested in therapeutic jurisprudence, I could see that there were many theories being unconsciously used in the mediation process, both from the professions of law and psychology. So my initial attempts in my PhD were to describe how those theories could unite, interact, or otherwise contribute to form some major theory of mediation. With further research, however, my attention shifted from just describing how those theories interacted in the micro process of mediation to describing how those same theories became agents for social change, impacting the larger dispute resolution continuum of the ever-changing macro process for developing a civil society. I began by noticing in my clients as a practicing psychologist, barrister, and mediator over the years that the long-term effects of grief suffered from the experience of loss changed the very fabric of the society in which my clients lived. This was my first significant point of commonality between the two professions. For example, I noted how parties in the option generation and exploration phases of the mediation process engaged as researchers learning from their own experiences of loss to understand more about how that loss affected not only each other's worldview, but also affected each other's readiness and willingness to make an agreement which would minimize loss in the future. I noted that the experiences of the parties in the option generation and exploration phases actually refined their personal growth skills as they gained more understanding of each other's worldviews. This learning accorded with the 12 stages of Kathy Charmez's work on grounded theory, where she claims that we learn best from events. Oh dear, sorry, it's just gone. I'll get that back in a minute. I'm so sorry about that. I think that might be better. Yes, this learning accorded with the 12 stages of Kathy Charmez's work on grounded theory, where she claims that we learn best from events grounded in experience, or via grounded research, as she says. I demonstrated as part of my thesis that the parties unconsciously use Charmez's grounded research theory to confirm their grassroots learning around loss, a process which I claim is implicit in any mediation. This awareness of how Charmez's work is unconsciously used by the parties in the mediation process to understand more about the impact of their loss on each other led me to consider how grief and loss also change not only the consequent social relations of the parties on a micro level, but change the consequent development of civil society on a macro level. It seemed that there was some sort of holographic relationship between what happens in a mediation on a micro level to make some sense of loss and what happens in civil society on a macro level to minimize loss. The one affects the other, and this awareness subsequently led me to the work of John Dewey's pragmatism. John Dewey was an American educationalist in the beginning of the 20th century who believed that democracy was best served in small-town America through the cooperation of its disparate groups, which together could educate each other about their respective needs and interests in building a series of functional and peaceful communities within the town. Dewey emphasized the importance of education to meet the ever-changing social and economic needs of each of the groups, and believed that their rights were already enshrined in the principles of law, and that their rights formed a stable but malleable boundary, and I stress the word malleable, in which their ever-changing needs and interests could be met. He termed this process where everybody had a say in balancing the needs and interests of the disparate groups within a legal framework, pragmatism, which was in essence an attempt at a dispute prevention process in the development of a democratic civil society. I realised from Dewey's work that the process of mediation also deals with the disparate needs and interests of the parties as they co-create an agreement within a legal framework where each could better live with their respective losses, and that the process of mediation was in itself an attempt at a future dispute prevention process. Dewey realised that there was a two-way interaction between the individual and society, where the one made up the other, as if the interaction was an interdisciplinary response between the psychology of the individual and their needs on the one hand, and the development of law to administer society on the other. He stressed that there was no such thing as the individual outside of the relations that contributed to the formation of that individual. Relationship then was, for Dewey, the most important element in any interaction, and education was the means to understand the relationship, whether that interaction occurred between people in the environment, or in any other combination. Dewey was such an effective educationalist that he influenced the work of George Kelly, who applied Dewey's principles to the workings of the inner mind of the individual to develop his personal construct theory, otherwise termed the individual's worldview. Like Dewey, Kelly emphasized the significance of relations, whether those relations were with the environment and or with people, and stressed, like Dewey, that it is only through our relations that we can actually apply meaning to the events in our lives as part of our worldview, that is, as part of our personal constructs. I realized that each party in a mediation brings with them their own worldview or personal construct, and that acknowledging that worldview is fundamental to the parties feeling that they have been heard and understood. I further realised that educating the parties about each other's worldview assists with seeing different perspectives so that adherence to their own rigid perspective may become more malleable. The views of John Dewey and George Kelly were a forerunner to the views of Kenneth Gergen, who in his book, Relational Being, defined the way we relate as a game in the making, much like children making up rules as they go for the game of hide and seek. Gergen's account of relational being is best described as the process of being in a world of relations where things are experienced personally, but agreed to collectively to form a higher level of truth. This higher level encapsulates each party's specific version of truth or experience, much like the six blind men describing the elephant in the room from their vantage point. Each blind man is correct in their description of the elephant, which is their truth, but none is correct in describing the whole elephant. It is only when we share the information that we gain the bigger picture. So too, the process of mediation can be likened to the game in the making, as the parties come together to explore their personal experiences and share their grief, to collectively form an agreement that hopefully minimises loss in the future. That is, in mediation, it is only when we share the information through the exploration of issues that we can walk a mile in the other's shoes, to see the world from a more encompassing or higher perspective. In my doctorate, the concept of seeing the world from a holistic perspective was best explained by Vargo and Silversberg's mindfulness theory, where a framework for understanding the neurobiological mechanisms of mindfulness is explained through the concepts of self-awareness, self-regulation, and self-transcendence, all concepts to maintain the learning from our personal experiences, or in Chalmers' terms, to maintain the learning from grounded research about the experience of loss as we transact with and are made up via our transactions with the world. Vargo and Silversberg's theory stress the significance of relations and accord with Gergen's theory of relational being. Both Dewey and Kelly would agree with Gergen's relational being theory, in which Gergen claims that even the most consummate loner is in relationship with his environment and is therefore intricately connected with it, so that there is no such thing as the individual outside relationship. The act of being in the world for Gergen is a holographic experience, in that the personal experiences felt on a micro level simultaneously create collective responses on a macro level. By noting how the psychological theories implicitly unfold in mediation, I adapted the information session that was developed by Di Gibson and used by the mediation unit of the Sydney Registry of the Family Court in the 90s to develop my Reconstructionist model of mediation. The Reconstructionist model includes an educational platform for the parties to assess their own level of readiness for effective participation in the mediation process. My thesis describes at length how the Reconstructionist model is used, but for the purpose of this talk, I will describe the psychological theories that make up its educational platform to assist the parties. The most effective theory of the educational platform comes from Isolina Ricci, who also stresses the significance of relating with ourselves and with the environment, and accords with Gergen's theory of relational being. Her work on the 4 stages of relating originates from considering the impact of divorce on children. She explains the first stage to be acquaintance or business stage, the second to be friendship, the third is called positive intimacy, and the last stage is termed negative intimacy. These stages offer a roadmap, she says, for each party to know where along the 4 stages they currently stand. She claims that whether the transactions are in family law or commercial law, the best stage that allows the parties to move forward from their loss is when they are ready to move from negative intimacy back to business or acquaintance stage, and that is much easier said than done. She also claims that both parties must have passed through the stages of shock and grief before they can return to the business acquaintance stage in a constructive frame of mind. Conducting the mediation at a stage where the grief for one party is still high will not only be unsuccessful but could also be harmful, hence highlighting the significant role grief plays in resolving disputes. From Gergen's work, I realised that the process of mediation, as stated before, could similarly be described as a game in the making. That is, as a way of mindfully dealing with the reality of the moment as it constantly unfolds. I then further realised that the implementation phase of the parties' agreement, which I have termed the observer self in my thesis, is where the parts of the agreement are thoroughly reality tested to include contingency plans if the expected outcomes are not met. This observer self phase can be described as the process of constructing a public social order from the terms of a private contract. I realised that the micro perspectives of theories like the grounded research of Cathy Chalmers and the macro perspectives like John Dewey's pragmatism represented a holographic aspect of society, where the micro world of mediation reflected aspects of the macro world of the civil society. That is, mediation could be better understood not just as a micro-settlement process for a specific dispute, but also as a macro-social change agent where the parties as individuals are better accommodated into a society of experienced relations. The focus on the interdisciplinary theories of law and psychology when engaging the mediation process led me to make the following claims that formed the foundational elements of my thesis. The first claim is that disputes are a common part of everyday life and occur whenever our expectations are shattered and an attempt is made to redress the loss. The second claim is that we attribute meaning to every event of our life, and we do this either consciously or unconsciously. The meaning we give to events arises from our value base or our beliefs, which in turn arise from the shared assumptions we make about how things relate. The third claim is that the impact of grief on decision-making proportionally affects the outcome of the dispute, such that the greater the grief felt, the less likely that a settlement will occur. The fourth claim is that the series of exercises offered by the educational platform in a Reconstructionist model, termed the normative information session, enables the parties to determine whether they are ready, whether they are willing, or whether they are able to address each issue of the dispute to the point of resolution. My claim here is that any dispute can be resolved, provided both parties are ready, both parties are willing, and both parties are able to do so. My final claim is that an interdisciplinary approach to mediation, otherwise termed a social constructionist approach, enables the essential organic nature of our humanness to be fully experienced as it arises out of grief from the loss. I further claim that this essential nature of humanness cannot be recreated or supplanted by artificial intelligence in an exponentially advanced digital world, but can only be experienced and felt personally to enhance a cherished life of relations with the world, as well as a life of cherished, chosen relationships because of the suffering of grief from loss. As stated at the outset of my talk, this is why I claim that loss fuels the meaning we give to life. Of these 5 findings, the second finding, that meaning only arises from shared assumptions about how things relate, forms the crux of the thesis. For example, if we accept that we attribute meaning to every event in our life, then the process of relating is itself a process where the parties attribute meaning in the form of a social contract based on their agreements about what they believe or assume to be shared meanings or terms of the contract between them. This understanding follows the work of Niemeyer and Sands on bereavement, loss, and suicide, where reconstructing a world of meaning that has been challenged by loss is crucial for the parties to move forward after a tragic event. It also accords with the 5 stages of grief by Elizabeth Kubler-Ross in her model for dealing with death and dying, which, although a little outdated, still forms an easy scaffold for the parties to address their own levels of grief. By engaging as grounded researchers and using a framework of exercises for asking questions about the reality in which they live, a framework which I've termed the normative information session, the parties are offered an opportunity to reconsider or to change their original meaning given to the impact the loss has made on their life to a meaning that can be better endured as they continue to live with the loss. I will not have time to go through the framework of the NIS, which can be a topic for another time, but suffice it to say that the normative information session constitutes the main difference between my Reconstructionist model and every other type of mediation. Traditionally, the problem-solving mediation processes such as the facilitative, evaluative, and settlement models all place their emphasis on settlement, not on the relational aspects between the parties. These models, therefore, I claim, need to be rethought and reconceptualized to allow for a social constructionist approach that can inherently deal with the loss through the process of relational learning, where parties can better accommodate each other's perspectives to construct a new reality together. Mediation can be seen, therefore, to be an organic process when both parties are encouraged to accept that any misunderstandings between them can only be clarified when the grief is set aside sufficiently for the same meaning to be accepted by both sides as being the common facts of the case. If, for example, in a personal injury matter, the applicant sees himself or herself as the victim of psychological bullying in the workplace, and the insurer claims that the applicant was in fact being the bully, the matter is unlikely to resolve until both parties can accept that there is such a major difference in the interpretation of the facts, for which a major compromise on both sides is required to reinterpret the facts in a common light based on the evidence on the file. My claim in the thesis is that meaning reconstruction following loss is an inherent, albeit an invisible or even an unconscious part of a social constructionist interpretation of mediation, and that such an interpretation extends the dispute resolution continuum to include law at one end and psychology on the other, as helping professions that assist parties make sense of loss, both on an individual and societal level, respectively. This process makes the resolution of disputes a process for social change. My further claim is that every mediation unconsciously offers parties that same opportunity for social change. But a social constructionist model consciously offers parties that opportunity, as does each of the professions of psychology and law. For instance, each profession, law and psychology, has a distinct set of protocols and criteria with which to assist the public to resolve or settle their dispute. Psychology deals with the idiosyncratic and unique interpretations of individuals when attempting to fulfill their own needs by making sense of their loss. And law definitively deals with the individual's rights following loss to establish a fair society. As inherently understood, the function of law is to set rules and principles with which to regulate behaviour and determine when we have come into conflict. Law tells us exactly what is lawful and what is not. The function of psychology, however, is to explain the human psyche. Like law, psychological research similarly demands a degree of empirical correspondence between ideas and data to be definitive about the nature of the human psyche. In its pursuit to explain the human psyche, psychological research is walled off from the messy reality in which we must all live. In practice, however, the clinician in real life cannot rely on a broad set of principles that states definitively what to do or say, let alone when to do or say it. So in its attempts to be scientific via an evidence-based approach, the aim of psychological research is to assist the clinician or the psychologist in their daily practice to ask difficult questions when doing their work, so that they can remain skeptical of oversimplified explanations about the human psyche and can also remain skeptical of reductive answers to complex questions. In this way, psychological research, like legal research, serves as a corrective to maintain our humanness and not to be reduced to a digital number. By using psychological and legal research as correctives, clinicians and lawyers can guard against the pervasive human temptation to construct a narrative that matches their own preconceptions, and can guard against the human temptation to construct a narrative that further matches their unexamined biases in their attempts to cure or to acquit their client. These measures, I claim, offer a social constructionist view of the holistic approach required by both psychologists and lawyers when helping the public to resolve their disputes, and offers parties an opportunity for personal and social change. Where then does mediation sit along this dispute resolution continuum in its attempts to resolve disputes? I've made the claim that the uniqueness of any mediation process, unlike other social processes, considers the individual's needs, that is, psychological needs, in the context of their legal rights to serve the individual's best long-term interests in a structured format that results in an interplay for mutual social exchange, best described as the interplay of the individual in society. I claim that an organic social constructionist interpretation places it uniquely between the two professions of psychology and law, something like a marriage between law and psychology where mediation utilizes intrinsic elements from both. A reconstructionist model, however, unlike other mediation processes, attempts to make the parties and the mediator consciously aware of that interplay of processes in which they are simultaneously engaging as relational learners, or learners about the relationships with each other. That is, in a social constructionist version of mediation, the parties engage consciously as joint researchers grounded in their unique experience of loss, exploring the meanings, with which they can best accept their loss and still enable a functional worldview that can at least be tolerated and managed, if not preferred, into the future. A social constructionist approach to mediation offers an exercise to the parties via its educational platform in the mediator's opening statement for the parties to measure their own levels of readiness, willingness, and ability to move forward against the norm. A social constructionist model also offers the mediator the opportunity to similarly become a relational learner with the parties, exploring the parties' unique worldviews as grounded researchers and encouraging the parties to be consciously aware and mindful of their feelings and thoughts in a responsive, not a reactive way, so that we can walk a mile in each other's shoes. Throughout the whole social constructionist process, the mediator engages as a mirror, reflecting to the parties what they are experiencing at difficult moments in their game in the making, and confirming with the parties if the mediator's interpretation is the intended or desired interpretation. The mediator's role is to prepare, to anticipate, to notice reactions of self and parties, to respond, to strategize, and to adapt to whatever is required or whatever unfolds in the game in the making. And by so doing, becoming a constant, mindful, relational learner in teamwork with the parties, ever willing to consider each party's microscopic variations of understanding evident in their interpretation of the terms. In other words, the mediator highlights the distortions in understanding of the parties and refers to them as a communication problem, which may result from a simple misunderstanding of facts, or could be indicative of differences not only in the parties' relational style or transactional analysis state, but more deeply, it could be a difference in their value structure. A difference, in fact, can easily be remedied, such as, for example, when both parties in a job interview agree on a figure of $75 to be paid, and find at the time of signing the contract that one party understood $75 an hour, whilst the other one understood $75,000 per annum. A difference in relational style, however, is much harder to overcome, as it includes the assumptions forming the values and beliefs of each party, which may not be consciously obvious to the parties themselves. The difference in values is best described by Eric Berne's transactional analysis theory, where he claims that human transactions occur in one or more of three ways, that is, through the child, or the feeling creative channel, or the parent, that is the moral thinking channel, or the adult, that is the empathy compassion channel, where we experience humor, which Berne claims is the best form of learning. He confirms that the best communication styles occur when the adult of one party communicates with the adult of the other, and the worst communication occurs when the parent of one communicates with a child of the other, or the parent of one communicates with the parent of the other, and both take a positional Mexican standoff where neither is willing to give way. To this, I have added the concept of observer self in my thesis, where the best reality testing for the proposed agreement takes place, and where the agreement turns from being a private contract between the parties to an implemented public social arrangement. The input from the mediator to explain the forms of relational learning between the parties can therefore empower the parties to recognize that their loss, be it in the form of the family trouble, the emotional disturbance, the bad business deal, which is brought into meaningful existence by being talked into being in everyday life, is in fact a construct that has been talked into existence. And as a construct, it can also be changed, that is, talked out of existence. The practical workings of what is constructed and how the construction process unfolds constitutes the actual game in the making, and constitutes the beginning of an altered worldview with its consequently altered social order. A social constructionist process, therefore, offers parties the opportunity, both jointly and severally, to play a critical role as co-creators of their future in every dispute, and it offers every such mediation an opportunity to change society. In other words, like psychology, a reconstructionist model to mediation offers the parties an opportunity to correct against their own preconceptions and unexamined biases through the assistance of a mediator who is invited, whether voluntarily or otherwise, into the parties' respective messy worlds. Set within a framework of legal rights, parties in mediation can choose jointly and or severally to forego their rights, to pursue what is in their best long-term interests within the parameters of the law, prompting them to change the way they relate, to form new functional groups, hence combining aspects of both psychology and law that work best for the parties under their specific circumstances to become social change in the process. A social constructionist procedure identifies the ways of relating that led to the losses and can create an opportunity to form new ways of relating to avoid further loss. In social constructionist terms, the process of organic mediation is not only mindful of the impact of law on the psychological well-being of the parties, but becomes the social change agent when it implements the agreement of the parties, changing forever the foundation of their relationships to a form that both parties can better live with. Through a social constructionist model, the parties are encouraged to consciously be aware of their feelings and thoughts as they constantly weigh their individual needs against their rights to determine what is in their respective best practical interests as they make sense of their losses. And by implementing their final agreement, the result from their game in the making not only makes sense of their losses to the best of their ability, but also contributes to the evolution of a fairer society. And in this way, I claim that loss again fuels the meaning we give to life. As an interdisciplinary process, and social constructionism in constant action can be seen as the ongoing and evolving interaction of the way the individual relates with others in society and with his environment to maintain our humanness. An organic social constructionist interpretation of disputes as the game in the making could therefore do for the helping professions of law and psychology what the natural sciences of physics and chemistry have already done for engineering and biomedicine. The social constructionist approach focuses on the impact the loss has made on the emotional, financial, and psychological well-being of the parties. For instance, the emotional impact associated with loss affects the party's ability to let go of the original meaning attributed to the loss or to the original terms of the contract. As the emotional impact of the loss varies for each party, it affects their readiness to move forward, which in turn has a direct financial bearing on the outcome of the contract. This is most obvious in personal injury claims, where the financial expectations for damages claimed by the applicant are directly linked to their understanding of fairness for the loss of their previous lifestyle. If the grieving for that loss of lifestyle is still very raw, the financial expectations for damages will be very high, with a consequent inability to realistically assess the constraints of the legal process. It is only once the grieving has been reconstructed into a more viable form to honour the loss suffered that the constraints of the legal process can be realistically assessed to gain an outcome that suits the needs of both parties. Under an organic social constructionist interpretation, the conscious and open acknowledgement of the losses of one party by the other on a substantive and emotional level creates an opening for the shift of meaning to occur for each party. In other words, acknowledging the existence of the other party's construction of truth or reality without necessarily accepting it creates more willingness to settle or move forward as principles of right and wrong, which is inherent in legislation, give way to pragmatism and practicality, as Dewey would say. In other words, acknowledgement of the other party's truth removes the need for each party to persist as rigidly to holding on to their own social construct of the truth as if there was no other, and allows an opportunity for the co-creation of new meaning to overcome the emotional and substantial impact of the loss that is termed making a commercial decision or cutting your losses as a lesson learned to move forward. To that effect, adopting an organic social constructionist approach to appreciate everyday reality constructing practices can effectively explore the meaning we attribute to loss, thereby making sense of it. Some studies view mediation and litigation as theoretical constructs which occupy opposing ends of the same procedural continuum of dispute resolution, rather than seeing the continuum between psychology and law. A social constructionist approach, however, contends that any examination of dispute resolution calls for a re-examination of the underlying assumptions regarding the nature of law, as it heads the public end of the dispute resolution continuum, and the nature of mediation at the private end of third-party interventions for dispute resolution. In social constructionist terms, law can be seen as the game which aims for fixed rules, as opposed to mediation, which is seen as the game in the making. As mentioned above, law is characterised by procedural fairness, openness and transparency of proceedings for the sake of natural justice. Mediation is characterised by flexibility of procedure, confidentiality and closed proceedings for the sake of privacy, which does not necessarily include natural law. Law contributes to the principles of justice that comprise the rule of law by which nation-states are publicly governed, whereas mediation contributes to the private arrangements between individuals that allow pragmatic and practical solutions to unfold as concepts of day-to-day justice, which emerge as the way business is done here. From a social constructionist perspective, concepts of day-to-day justice similarly call for a re-examination of the broader practical principles of access to justice within the legal system. Access to justice principles are commonly referred to as third-wave reforms, otherwise termed alternative dispute resolution, of which mediation in its various forms, as stated above, comprises the private end of the dispute resolution continuum of third-party interventions. Models of therapeutic jurisprudence, individual case management, and court-connected ADR, alternate dispute resolution, are all access to justice measures adopted as part of the third-wave reforms of the legal system, all of which have varying degrees of public-private exposure and all of which, like mediation, are examples of non-adversarial justice. A comparison between therapeutic jurisprudence as an alternative dispute resolution measure at the public end of the continuum and mediation as an alternative dispute resolution measure at the private end of the dispute resolution continuum shows that both share a common vision to engage a holistic approach to deal with the impact of law on the psychological well-being of the clients, and both aim to implement a broad framework for appreciating, not critiquing, everyday reality constructing practices. To that effect, and as mentioned above, adopting a social constructionist approach to appreciate everyday reality constructing practices can effectively explore the concept that meaning reconstruction following loss is an inherent, albeit invisible, unconscious part of every dispute resolution procedure, which extends the dispute resolution continuum to include law and psychology as helping professions to resolve disputes. Mediation can therefore be seen as an interdisciplinary process, the purpose of which is to balance the rights and needs of the parties with what is in their best interests. In considering the claim made by Boole and others that mediation is a practice in need of a theory, I claim that a social constructionist interpretation of mediation offers such a theory, as it enables the various processes engaged in mediation to be consciously experienced by the parties. By engaging a social constructionist approach with an educational platform such as the normative information session, the parties become conscious of and engage in the micro-processes with the following theories. They engage with Kathy Charmez's grounded research theory, where we learn from events grounded in our experience. Kenneth Gergen's game in the making theory, where there is no such thing as the individual outside relationship. Iselina Ritchie's 4 stages relational table from her greater study of the impact of divorce on children. Niemeyer and Sand's meaning reconstruction theory. Eric Byrne's transactional analysis theory, Vargo and Silversberg's mindfulness theory, and Elizabeth Kubler-Ross's 5 stages theory from her work on grief and loss in palliative care studies. They are just some of the theories that we engage in unconsciously in the mediation process. The second half of my thesis discusses the macro perspectives of dispute resolution in the work of John Dewey's pragmatism, where the needs of the disparate groups that make up a town can be understood and accommodated for by the townspeople via education to implement democracy. George Kelly's personal construct theory, which took the concept of Dewey's pragmatism on a macro scale and applied it on a micro scale to the individual's various psychological needs, to make his personal construct theory, which describes how the individual's disparate needs can be constantly refined through the individual's education to make up their worldview. In addition, a fuller analysis of the social constructionist process discusses how the microanalysis of the mediation process can assist the macroanalysis of how social changes can be institutionalized to change the very fabric of society. Both Dewey and Kelly would agree with Kurgan's relational being theory, resulting in his statement that there is no such thing as the individual outside relationship, a concept which brings us back to the significance of relating with our humanity intact as we give meaning to the events of our life that cause grief from loss. This takes us back to the beginning of my talk to confirm that loss fuels the meaning we give to life. As I have no further time, I'll provide these notes to further explain what I've presented. But to conclude, a social constructionist approach to mediation offers the theory for mediation where it is no longer just a practice in need of a theory, but a practice to enhance a cherished life of relations with the world, as well as a life of cherished chosen relationships arising from grief through loss. As stated at the outset of my talk, this is why I claim that loss fuels the meaning we give to life and why mediating loss offers the opportunity to develop a more humane society. That's the end of my talk. So, over to questions.
I thought it was brilliant. Thank you. You mentioned you'll give us the notes. Did I get that correct, or did I miss? Yeah.
No, I will give you the notes. I will. I know. They're heavy concepts. I tried to read this to my partner, and he was like,
so I noted that you referenced from some brilliant authors, so I thought I'd really like maybe some of those references, and I know you cited from some of their books as well, or their papers.
Yes, look, it's just amazing. I feel that through the mediation process, I've managed to kind of integrate all aspects of my life, from law and psychology. And it's just amazing how, law basically deals with the macro elements and psychology deals with the micro elements, and mediation deals with both. It's the individual in society. And it's just... The other thing that's significant, I think, and what excites me about mediation more than anything else, is that it really does empower the individual, and that by empowering the individual, it really does change society. So it really is from a grassroots up sort of, change of process. And
I just had one more comment about your comment about the shock and the grief once they get through that, and the mediation process is a lot more effective, I think you said. I made that note. I thought that was really interesting.
Yeah. And I think that's, it gives people the opportunity to get past their grief and their shock, and to recognize that that is a normal part of life, and that everyone goes through those processes at very different stages, so that you just have to recognize that some people will take longer than others, and some people will do it differently to others. And we all go through the process. So it could be us next time, and you would want the same courtesy for yourself, from someone else as you are willing to give to someone else. And I think it's I love the mitigating aspect of it, and the fact that law at least recognizes that every individual is different and that there are mitigating circumstances. And mediation allows both parties to reconstruct around those mitigating circumstances to say, well, how do you guys want to survive now? How do you want to deal with the losses that you both suffered and move forward from this? What did you gain from this? And that's where you get the personal growth.
Thank you so much. Yeah.
Good.
Glad you found it interesting. I was kind of worried about, the large words.
Oh, no, I thought it was great. No.
Any other questions?
Yeah, I really relate to what you've been saying. I have a background in law and psychotherapy, so I can sit. In fact, in my practice, I find I meld those.
Yeah.
I have a question that comes out of some of the things you've said about preparing the two parties. Would you advocate exploring some of those things with them in the intake sessions?
Yes, I do. In fact, I've got a couple of mediations that I'm doing at the moment, and it's one of the most difficult things. And I always have a pre-mediation teleconference or a Zoom conference with the parties and their solicitor together, because it's surprising how when you want to, the only question I ask is, how did you get to where you are today? how did the whole process unfold from your side? I just want to hear your side of the story. Now, I've read all the documents and I know what the case is roughly about, but from your perspective, how does it look? Tell me so that I can be you. And when they unfold that story and tell me on what basis they got into the social contract, if it's a franchise dispute, or how they met, if it's a family law dispute or whatever, you'd be surprised that when they hear that story, the solicitors themselves have never heard that story. And that is an eye-opener to the solicitors as well, because it then just helps them to get a better handle on what they're dealing with their client. And it also gives you an indication of whether you're going to get any movement from that client. Because if they're really still entrenched and will say things like, I hate his guts and I hope he dies, they're not ready. And so you're not going to get a long-term effective settlement. And that's the reality of the process. And so it's not about just settling for the sake of getting numbers up. It is about giving people a chance to actually understand and go through their own personal growth experience.
So you would also perhaps explore some of the theories that you've put forward without talking about them as theories, but to have that in the background in discussing with them during the intake.
When I actually talked about the normative information session, I actually have got a PowerPoint presentation, and I actually use that PowerPoint presentation at the beginning of I use that as part of my opening statement, because I've already then done one pre-mediation conference with them. Sometimes it might be necessary to do two, depending on exactly what the issues are. But then after we've done that, when I do my opening statement at the mediation, I will go through this and I will say, we're just going to go through this quickly now, just so that you're both on the same page and that you both understand what we're aiming to do here. And, neither one of you is going to get exactly what you want, but we're going to go through this so that you can actually understand where it's coming from the other side's perspective. Because you can write a book about your own perspective, but that's not what mediation is about. Mediation is about you understanding the other side. And if you can't understand the other side, you're not needed in the mediation. Now, unfortunately, in franchise disputes and in others, you've got people who are stuck there. And when that does happen, that's why I like to have the solicitors, because if you put the solicitors through the pre-mediation process as well, then they've heard those stories. They know the level of pain. They know the capacity, the ability of the parties to move forward. And I say to them, look, your clients are still too hurt, whatever, they're not going to move forward. I'm now going to need you guys to actually do what is in their best interest. You know that they could go to court for 3 or 4 days and one's going to lose, one's going to win, and it's going to ruin the family. But what can you do being the other side? If you were the solicitor for the other side, how would you actually work with this? And knowing what you know about your own client and about what your client's going to accept.
Thank
and
you.
It works really well when that happens, because they'll come up with solutions that you never would have thought of. And it's only made possible by the fact that all you're doing as a mediator is providing the opportunity for that magic to happen between them. And it's just amazing. It always is. I have been doing this work for over 30 years now, and I'm still stunned. I walk into a mediation, I think, I don't know how they're going to settle this. There's absolutely no way. I can't think of a way forward. And somebody will say something, and it'll trigger something in someone else, and they'll come up with some alternative, and they'll say, oh, yes, we can do that. Yes, that can be done. And all of a sudden, you're on the way to settlement. And if you don't provide that opportunity, it would never happen.
Thank you.
You've really got me on my high horse now. I'll be raving on about my mediations. My kids are sick of me. They're saying, oh, you only ever see the world as a way of mediation. It's true, though. It really is. It's all about relationships.
I was just going to say, we recently I'm in WA, so we're 3 hours behind you. We recently had Mr. Christopher Boyle come and speak. He's on the mediation board, which I'm sure you know of. He was brilliant, and he was just talking about one of the points he made is that mediation is really the way to go, and people are less litigating and looking at or ADR, any form of ADR that would work, even arbitration. He wrote he was just talking about how the NEMAS is being superseded by ADRESS, I think.
Yes.
I think that's the acronym anyway.
Yeah.
So, yeah.
Well, that'll be an interesting, it'll be very interesting to see how they're going to put that forward and what they're going to say with it, because it's still part of the consultation process. So we'll see how that unfolds. But I think as far as if you look at the globalized world and the globalized economy and where we are with climate change and everything else,
Yes.
I honestly can't see that anybody's going to get any benefit out of another war.
Yes.
We all know what the terrible devastations are about that. And I just see that the only way forward, particularly for a globalized economic world, is going to be through dispute resolution. There just isn't any other way. And this is the most effective way. It's been proven again and again. It's happened since time immemorial.
And
it's just that we're now consciously aware of it.
Do you think the last 5-10 years, the last decade, it's become a lot more prevalent that people are looking at going through that medium now, as opposed to litigating? I'm a lawyer as well, but yeah. I just think,
Well, I've been at the bar now for, God, I think it's 27 years, but I know that the point Sydney is the hardest bar. It is a very hard bar. And I mean, if you listen to some of the High Court judges, they'll say, that the lawyers from Sydney are the most litigious in the world that they've come across. And I'm not surprised about that. And it was an extremely difficult place to break into for ADR. If it wasn't for people like Sir Lawrence and Mary Walker and people who have constantly sort of, lobbied for mediation, I don't think it would have happened in the Sydney bar. But it is now happening and it is now being accepted, and that's a huge thing. And so I think that if we've managed to break it here, we can actually work it on a global level. And I think it will have to happen on a global level. That's just my thoughts about it, and particularly as we get more and more AI, because for as much as, all of the AI, and all three of my boys are into computing and whatever, and they say, there won't be any need for lawyers, it'll all be done by AI. And I think, well, yes, but it can't, unless they put in some sort of emotional component, it's not the same as dealing with the grief and the loss and, the relations and the quality of relations. And, unless you're going to be marrying your AIs like they do with some parts of Japan where, you marry your toys or whatever.
That's a frightening thought.
Who knows what the world has in store for us as we go on. I just find it fascinating. Any other questions at this stage?
Just a comment. I can foresee a time in the future where we may be mediating between humans and AI.
Look, I don't think anything's impossible. And if they say, it's this whole concept, isn't it, of what is consciousness, really? And when you putting bits of machinery together in a particular way, which allows for self-learning, is that consciousness? And if it is consciousness, then are they alive? What is being alive? It's just, they're very major questions, and I don't know that philosophy has ever answered them effectively, but, we keep asking. I think that's what we can do.
I don't think a human touch and human empathy and compassion can ever be replaced.
Yes, that's what I think too.
By any AI robot. I do know that the firm Allens have got their own AI, have developed their own AI product called Airly. I don't know how effective that is, but I know there was a webinar recently talking, one of the Allens directors was talking about that. They've developed their own AI because they didn't trust the chat GPT type model.
Yes.
So I don't know how effective that is, but I think it's interesting that more and more law firms are adopting that. But having said that, you can't in any way underestimate the empathy and compassion, and the listening and the value that comes from having real people on the other end.
I guess it's our humanness, isn't it? I mean, are we just a conscious being, or is there more to our humanity and our humanness than just consciousness? And then you get into the field of spirituality and philosophy and everything else. And, you know, we can go on and on. We can have these lovely discussions forever. Okay. I don't know if there's anybody else that wants to say anything. There's something in this chat here. What are they saying? Enjoyed the talk. Thank you. Okay. Anybody else? Jan, do you want to say anything? I noticed you've been there for a while.
I think she's on mute. Are you on mute, Jan?
I think I've just come off. Can you hear me?
I can, yes.
I thoroughly enjoyed it. It really has got the brain cells moving. There was a lot in your talk today, so I will be interested to see the notes just so I can go through it again. But no, and the chat I've really enjoyed listening to people and again, some of the ideas that have come up out of that chat, very, very interesting. Stay tuned is probably the way to go. Thank you very much.
Thank you very much too, and thank you for being so interested in the topic. I'm very pleased because it is a very great passion of mine, and I just think that, you know, it will be the way of the future. I'm quite convinced of that. I just think that it gives me hope for my grandsons, because I think, you know, you wonder, some of the younger generation, the millennials, start to feel incredibly disturbed about the fact that we've taken away their future and the world is now so stuffed, and it's all, you know, the booming generation. They were the ones that did it all, the horrible things. But I think that this sort of thing gives you hope, and because it does empower the individual, there is so much healing in acknowledgement, and people just don't appreciate how much healing there is in a simple acknowledgement. And that's mostly what people want in a mediation. They want their hurt to be acknowledged. They can then move on, but they want that hurt to be acknowledged, and that's so important. It's a very fundamental part of the healing process, and that's what mediation offers. I don't know of any other process that does that, which is why I'm so wrapped in it.
I think mediation does effectively address that issue, but because some mediation and ADR are not successful.
Well, I think that, you know, it depends entirely. I remember we were having these discussions with Jennifer Dave, and I was extraordinarily lucky to be trained by the best as far as I'm concerned. You know, all of us that were trained by Jennifer and Ruth Charlton and Micheline Dewdney and those initial women that really set this thing up, we had these discussions, and they would say, look, if it changes and it becomes too rigid, because people would say when arbitration began, it was supposed to be a mediation type sort of venue, you know, where people could discuss and work through these issues. And as time went on, and particularly when the barristers came in, it became more and more legalized. And, you know, now it's just a mini trial, really. And it's so regulated that it's a mini trial. And people were saying, well, you know, will mediation go the same way? And who knows? It might, but what I'm saying in my thesis is that if you choose a social constructionist approach like this, and you recognize the psychology and the amount of psychology that you implicitly use within the mediation process, if you become consciously aware of that, the amount of moving forward you can do is unbelievable. But you have to allow the opportunity for it to happen. If you just basically focused on your own self as a mediator, I've got to get a result, you're not going to make the place, you won't make the space available for this to happen. And it is about you feeling comfortable enough in yourself and in your own level of understanding to recognize that, you know, you're not always going to get the answers that you want or even a settlement. And with a lot of my franchise disputes, when the parties come and they're so irate, there's no way that they're going to get a long-term settlement. And so you're not necessarily going to settle, but if you can assist them to get to that next state, to that next step, then at least they're a little bit further ahead than where they were. And that's not a failure as far as I'm concerned. And that's why I said in my thesis, and I do believe this, that provided both parties are ready, both parties are willing, and both parties have the skills, no point in doing it with someone who hasn't got the skills. But if all three of those are there, then you will settle, because you'll find something that you have in common that you can deal with. But it's got to come from both sides.
Yes. I'm just going to echo Claire's. Claire just wrote a little message, said, would love to hear you speak again. I'm going to echo that as well. So
thank you.
You have the time, and Resolution Institute, that would be awesome.
Well, I'd be very happy to do that as well. That sounds really good. I mean, I've enjoyed this session as much as I hope you have as well.
If I may say as well, an open discussion with you, what's the word missing me, but mediating comes to mind. But yes, an open discussion I think would be hugely beneficial.
Well, I mean, I think that, look, I'd be happy to do that, because I think that it's an area that, the way I see it, I started off in my early 20s as a psychologist. And in those days, you were able to kind of do a 3-year course, and you could select whether you wanted to do clinical, counselling, organisational, community, and all of that was open and available to you. As the years progressed, it became harder and harder and harder. And now it is as hard to get into psychology as it is to get into medicine. It is that hard. And each of those little areas, which were just little departments, have become specific fields in their own right now. And so now you've got, forensic psychology, and you've got, and they're all of them, you need a separate degree in each one. They're really, they've gone to that extent.
Why is that? Why has that changed so
Because it's because they've recognised over the years, I think there's over 4,000 psychologists in Sydney, and they've recognised that, it is definitely an area of need. Mental health is just absolutely crucial. And
did it escalate during the pandemic? Is that what you're referring
to?
No,
not necessarily during the pandemic. I mean, I don't know the figures about whether it went up or down in the pandemic.
Okay.
But I guess, what I'm saying is that over the years, psychology became more and more popular, because the truth of the matter is that it is always about relationships. Everything you do in the world is about relationships. So everything is about psychology. And you've got to understand why people do what they do, And so I can see why it's gone. And the reason I mention all of that is because in my mind, I can see mediation following the same trends. And I can see that, it's just a set of skills to start with, but now it's becoming a profession in its own right. And then once it becomes a profession in its own right, it will become even more specialised, and you're going to require, a law degree or a psych degree or whatever you might need to get into it. At the moment, it's a very good time to get into this area, because that hasn't all been stabilised yet. But now you've got MSB talking about Mediator Standards Board saying, oh, we're not just going to have NMAS anymore, we're going to have this address. And you're going to be a whatever mediator and a something else mediator, and who knows how things will unfold. And I'd be very interested to actually hear what they have to say and what the reasoning behind it is, because I don't know how they're going to separate out the categories, but that's for them to work out. That's not for us. We'll just be on the receiving end. Okay, well, I don't want to keep people too much longer unless but thank you very much. It's been a lovely talk. Thank you.
And thank you. It's been wonderful.
Thank you.
We hope to hear you again. Thank you so much.
Well, that'll be lovely. Thanks very much.
Thank you.